position to be Wednesdays.
The code for the door is 6010 pound.
Views, 13 viewers. Congratulations.
Yeah. Okay, so we're just going to wait a little while. Hello, Darren.
Hey, I'm back with you.
Okay, we're doing a live stream here, and so far it's just me and Nelson. But if anybody calls, wants to get in the front door, the code is 6010 pound.
6010 pound.
Yep.
6010 pound. Okay. Is G over there looking in case somebody comes in or wants to come in?
He's here. I'm not sure if he's looking, but he's here.
Okay, I'll let him know that you're doing it. Kenneth didn't go with you?
No, I guess he canceled out.
Okay. All right. Well, y'all have a good one then.
Okay.
You're going to report it too, right?
Yep.
Okay, sounds good. Talk to you later.
Bye. Guess I better censor or silence my phone. Okay, well, so what we're going to talk about today, I'm just giving it some time for some people to show up. We're in Dallas, actually Farmers Branch, which is metro area. And we should have a really good connection here. And what we're going to do is talk about the filing that I made today in court. Matter of fact, I haven't even had a chance to scan up the front page with the file stamps on it. So I had to run down to the courthouse. I left. It's the traffic. It's cold here, and people in Texas don't know what to do with the cold. And so it was 10 after 4. The court closes at 4:30, and I went down there. There was hardly any traffic. It only took me 15 minutes, 20 minutes to get there. Actually, it was less than 20 minutes. It was 15 minutes because I got there and the court was still open. They close at 4:30. Anyway, so what happened is I got this filed and then got back home and my printer, I was printing and stuff because I got to serve them. Anyways, so that's what happened. So this is a filing that I filed in court today, and we all need to know these arguments. What?
Is chat censored again? Someone's asking.
Sorry?
In the chat, someone's asking you, is it censored?
I have to approve all comments. Sometimes it takes time for me to do that.
Okay.
looks like it's just recording my chats. Anyways. So it's recording right now, and then I'll upload this to, this is going to be live streamed on YouTube, on my YouTube channel, but I'll upload it to another YouTube channel that I manage, the Republic of Texas YouTube channel. So this is a document that I filed in my lawsuit today. The way it works in the federal court is they give you a wannabe judge. Well, you don't have to accept it. Matter of fact, tomorrow I'm going to file a notice of objection to the wannabe fake judge. Anyways, so then the real judge will have to take over. So what they do is at some point the judge, whoever it is, if he's a wannabe judge, he'll make findings, conclusions, and recommendations to the judge. And so he's done that. He actually made a 20-page finding, but it's interesting that it's not a findings and conclusion of law. So anyways, so
Background of the case.
this is over property taxes, and so the important thing you have to do in federal court is set the record for appeal. Now in federal court, the motions don't get into the appeal record. This stuff here won't get into the appeal record, nor this, I don't believe. What'll get there is the brief, when you attach a brief. So you can sit there and make a motion and make all sorts of arguments, and it doesn't. I've actually had the courts dismiss a case, the Court of Appeals, because there was nothing for them. There was no appeal record. They're supposed to, what happens when you appeal it is the district court will send the record to the Court of Appeals, and then you can't bring up anything other than what you've already brought up. And so I've been doing that, is basically building a case for the appeal. Because if there's any place you get your rights violated, it's in these so-called courts. So this is actually, the way it works in the federal courts is that if you can keep your brief under 10 pages or under, then you don't have to have a table of contents or a list of authorities. If your brief is more than 10 pages, then you have to have a table of contents and a list of authorities. And so this brief is, and then it doesn't include the attachments. Okay, the attachments is separate. And so, and they don't want any footer. All you can do is put a page number on it, and that's it. So this one has a table of contents, and it's supposed to be an alphabetical list of authorities. So these are all the authorities and the pages that it's on. That's a bit of a pain in the butt to put this together, because I have to, the Word doesn't allow you to make them alphabetical. It's a bit of a nuisance. So um, so I just manually do it. It's a bit of a nuisance because I got to print off the table of contents and then go through and check all the page numbers and make sure that I got them down right. And then if I make any changes, it causes all the page numbers to change. So this is it's 25 pages. I'm not allowed to have a maximum of 25 pages for the brief, excluding the table of contents and the list of authorities. And so we have basically 5 pages of that. So then the brief is 29 pages. Anyways, so the first paragraph. So it starts off, it says, come now, demands notice in court of objections to the magistrate judges. So the purpose of this is for the Court of Appeals. Okay, so he's already trying to dismiss it. He's recommending that the court dismiss it, that the real judge dismiss the case. And so I filed this today. You have 2 weeks after they do their findings and conclusions. You have 2 weeks to object to it. And so, and if you don't do it within 2 weeks, then you can't even appeal it. So you have to get it in there within 2 weeks. So, buyer's fake judgment. That's the judge in the lower court. I'm doing a collateral attack on her fake judgment. So the demand and file this action is a collateral attack because of buyer's fake judgment that fails to have a court seal on it. Okay, if there's any court under the Authentications Act, it's supposed to have a court seal on it, and it's supposed to be signed by a judge. It is signed by a judge, but there's no court seal. Therefore, it fails to be a court, and is evidence that buyers was acting in her private capacity only on hire for her bar buddies under color of law, true copy of which is attached here to it in the appendix at pages 48 through 50, all of which is incorporated herein by reference in its entirety. So you got to incorporate it in because they play stupid, Anyways, buyers 97th District Court might have had jurisdiction but lost subject matter jurisdiction through denials of due process of law. A court's jurisdiction, though existent at the beginning of a proceeding, may be lost in the course of the proceeding by deprivation of constitutional rights. Thereafter, the court no longer has jurisdiction to proceed. A judgment rendered in violation of due process is void, and the rendering state is not entitled to full faith and credit elsewhere. Due process requires that the defendant be given adequate notice of the suit and be subject to personal jurisdiction of the court. Denials of due process of law. Buyer's fake court clerk, Robin Woods, refused the demandant's filings as evidenced by the unclaimed. Returned certified mail, which contained a challenge to jurisdiction as evidenced by the image of the unclaimed envelope, the challenge to jurisdiction, certificate of service, and the website, true copies of which are attached here too in the appendix, pages 51 through 71, all of which is incorporated herein by reference in its entirety, and we'll look at that after. Matter of fact, we can go look at it now if you want, 51 through 71 in the appendix. So the way you're supposed to do the appendix is you just sequentially number the pages. And so you'll see how I did that. So this is page 8. Yeah, that's buyer's fake judgment right there. See here? There's no court seal on it. See? That's it. That's all of it. 3 pages. So it's a fake judgment. And then this is what was in that envelope. Of course, they don't want that because they want to presume jurisdiction. There was a star chamber. See, the page numbers are sequentially numbered here. Here's the certificate of service. Certified mail on the attorney and the bar member scum. And they got it. And they knew that they got it. And they said it's just a railroad job is all it is. Anyways. And here's the certified mail saying that she got it. And here is the returned mail, unclaimed. Trish Coleman Byers, fake judge, eh? And here's their website. It said Post Office Box 167, Montague County. That's where I sent it. So anyways, I think it looks pretty bad for them. And then what they did is they sent a letter, a notice of court order, but it's not signed and there's no court seal on it. So anyway, so it's a star chamber. And then they went and assaulted me with this liar. And here's the order saying that I had to pay the filing fees. They got extortion, but there's no court seal on that either. It's quite a scam they had going on there. Anyways.
The objective is they're trying to steal your property.
Well, they did.
It might be helpful to mention that.
Sorry?
It might be helpful to mention.
Well, it'll talk about it in this. So anyways, well, this is probably going to go to appeal. We'll see what happens when the real judge looks at it. But I'm setting it up for appeal. And I'm prepared to go to the Supreme Court. But anyways, so Byers held her Star Chamber so-called court with her forced bar member counsel, as evidenced by the letter from Byers' bar buddy John Elyzy, a true copy of which is attached here too. We just saw that a minute ago. All of which is incorporated herein by reference in its entirety. And the fact that Byers forced the demandant to pay for it, the true copy of Byers' fake order with no court seal on it, as recorded by the Authentications Act, 1 Stat 122, which is attached here too at page 74, all of which is incorporated herein by reference in its entirety. Robin Woods failed to provide the demandant a copy of any judgment or orders in an effort to deny the demandant his right to appeal. It appears that the fake court clerk, Robin Woods, sent an unsigned document with no court seal on it entitled Notice of Court Order peddling their documents, a true copy of which is attached to the appendix at page 72, all of which is incorporated herein by reference in its entirety. And the demandant was expecting a copy of any judgment and thought it failed to affect him. Therefore, Woods operated to deny the demandant his right to appeal in support of her targetedjustice.com website. All of which is evidence that Byers' so-called court was a non-judicial proceeding working for the legislature under executive authority under her targetedjustice.com website, which means the judgment is a bill of pains and penalties. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purposes of such proceeding. That's found at 21 Corpus Juris Secundum, Courts, Section 2. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. And that's Book 20 of American Jurisprudence, 2D, Courts, Section 103. It is familiar law that when special statutory authority in derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc, a court of inferior or limited jurisdiction. A ministerial duty is one which is required by statute. Ministerial act is an act that a public officer is required to perform in a prescribed manner in obedience to the mandate of legal authority and without regard to his own judgment or opinion concerning such act's propriety or impropriety when a given state of facts exists. Discretion, on the other hand, is the power conferred on public functionaries to act officially according to the dictates of their judgment. The word administrative is synonymous with the word executive. The word administrative connotes or pertains to administration, especially management, as by managing or conducting or superintending the execution, application, or conduct of persons or things. The administrative acts are those acts which are necessary to be done to carry out legislative policies and purposes already declared by the legislative body. In fact, it is common to use the two words in tandem. Statutes, such as our maritime code, require administrative hearings. When acting to enforce a statute and subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating and enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial, not a discretionary capacity. It is the accepted rule, not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes. As a bought and paid for clerk, as a ministerial clerk for an agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency. Ministerial officers are incompetent to receive judicial authority. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. So it's a void judgment. The county of Montague bar members engaged in the theft of the demandant's land with their forced rendition, and their inferior legislative maritime court failed to be a trial by jury and absolutely failed to have anything to do with common law in violation of 1 Stat 77, Section 9A, and 36 Stat 1611, Section 256, Part 3. And it is an administrative hearing that failed to have an Article 3 judge, but was an executive branch administrator working for the legislature, which means any decision was a bill of pains and penalties, which is similar to a bill of attainder, because the inferior legislative courts are an extension of the legislature, and there is no Article 3 judge present. Therefore, it is a non-judicial legislative act targeted at landowners, and the demandant in particular in this case. A bill of attainder means legislative acts, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. A bill of attainder, a special legislative act prescribing punishment without a trial for a specific person or group. Bills of attainder are prohibited by the U.S. Constitution. Also termed Act of Attainder, see Attainder, Bill of Pains and Penalties, Black's Law Dictionary, 8th edition. A Bill of Pains and Penalties is a legislative act, though similar to a Bill of Attainder, prescribes punishment less severe than capital punishment. Bills of Pains and Penalties are included within the U.S. Constitution's bans on bills of attainder. Black's Law Dictionary, 8th edition, page 499. The demandant failed to give this so-called court any authority over the demandant, and this so-called court has no authority to make any legal determinations for the demandant or represent the demandant in any way. Will Livingston, that ratified the Constitution for New Jersey, 18 December 1787, is the demandant's fourth great uncle, and the demandant is posterity as found in the preamble. And so that talks about it there in the preamble. Entitled to right of blood, and no civil law can destroy right of blood, because all the laws of Congress and all the laws of Texas are civil laws. And right of blood and kindred cannot be destroyed by any civil law. And this court, as well as the wrongdoers, are operating under a power which is derived from the demandant as posterity, and the maxim says the power which is derived cannot be greater than that from which it is derived. And therefore it's impossible for the demandant to give any of these wrongdoers or their bar member handlers or this court any authority over the demandant, And John Marshall, the Chief Judge of the Legislative Inferior Supreme Court of the United States, agreed and said it's impossible for the demandant as one of we the people to confer a sovereignty which will extend over him. And this is McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They are given by the people of the United States to a government whose laws, made in pursuance of the Constitution, are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. And the demandant is exempt from these wrongdoers and from all the claims of their bar members, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And the demandant requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, which is the supreme law of the land. Anything in the constitutional laws of any state to the contrary notwithstanding. Article 6, Clause 2, Constitution for the United States of America. And we, the people, fail to be 14th Amendment U.S. citizens because the 14th Amendment U.S. citizen failed to exist when the Constitution was written. And all of which is evidence of the affidavit in the affidavit of citizenship, a true copy of which is attached hereto in the appendix at pages 1 through 24, all of which is incorporated herein by reference in its entirety. There is nothing this court can do to affect the demandant. State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. The sovereignty of a state does not reside in the persons who fill the different departments of its government, but in the people from whom the government emanated, and they may change it at their discretion. Sovereignty then in this country abides with the constituency and not with the agent, and this remark is true both in reference to the federal and state government. The wrongdoers in this case have repeatedly called the demandant a sovereign citizen, and it's true, as evidenced by the resolution of Congress, because we have a Republican form of government, we're all sovereign citizens, as evidenced by House Joint Resolution 183, dated March 3rd, 1940, at 54 Stat 178, says in the preamble, whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. The wrongdoers and their bar members are required to know that the Supreme Court of the United States has ruled that everyone and everything not privileged is sovereign, but the wrongdoers that have called the demandant a sovereign citizen like it's some sort of a bad thing, which is an attack against the republic itself, and repeatedly have taken reprisals against the demandant in support of their targetedjustice.com website, which is why demandant included the affidavit of fact of sovereign citizen and previous filings to show a long train of abuses and usurpations pursuing invariably the same object, evinces a design to reduce them to under absolute despotism, which is found in the Declaration of Independence, which is an attack against the republic itself, which is why the demandant is so sad and disappointed, because it looks like the judge is giving aid and comfort to the enemy in a time of war, or is mistaken, and the demandant's going to assume mistaken. Bar member emerging dictatorship. These bar members and their state bar of Texas is repeating history. In doing this, I shall have occasion incidentally to evince how true it is that states and governments were made for man, at the same time how true it is that his creatures and servants first deceived, next vilified, and at last oppressed their master and maker. A state like a merchant makes a contract, a dishonest state like a dishonest merchant willfully refuses to discharge it. Because there's an emerging bar member dictatorship in Texas, because they assault you with the Commerce Clause, Article 1, Section 8, Clause 3, with the plenary power of Congress, which is a dictatorship, which means no common law rights in violation of Article 1, Section 8, Clause 17. And if you object to it, they start name-calling by calling you a sovereign citizen and a terrorist, and then refuse to do anything to investigate or prosecute the felonies pursuant to their targetedjustice.com agenda, because they're assaulting the defendant with their regulations, which are for other property of the United States under Article 4, Section 3, Clause 2, which fails to include the defendant. The defendant filed bar grievances with the State Bar of Texas, regulated by the Supreme Court of Texas, against 95 different bar members, some more than once, and they were all dismissed as an inquiry. And the defendant filed dozens of judicial complaints with the State Commission on Judicial Conduct. Judges' educational curriculum is determined by the Supreme Court of Texas, and they were all dismissed, 25 on the same day. The State Commission on Judicial Conduct consists of 13 members. The majority are bar members, 5 judges appointed by the Supreme Court of Texas, 2 bar members appointed by the State Bar of Texas. The defendant filed hindering prosecution felony charges against every member of the Supreme Court of Texas in an effort to make them aware of what was happening, and nothing has changed. The County of Montague bar members engaged in the theft of the defendant's land with their forced rendition. That individual may stand upon his constitutional rights as a citizen. His rights as such existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure, except under a warrant of the law. So it's a warrant. They have to have a warrant of the law, these thieves, and they didn't do anything. They just stole the land. He owes nothing to the public as long as he does not trespass upon their rights. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. And their inferior legislative maritime court failed to be a trial by jury, and absolutely failed to have anything to do with common law in violation of Article 1 Stat 77, Section 9A, and 36 Stat 11, Section 256, Part 3. And it's an administrative hearing that failed to have an Article 3 judge, but was a legislative branch administrator, which means any decision was a bill of pains and penalties, which is similar to a bill of attainder, prohibited, because their inferior legislative courts are an extension of the legislature and there's no Article 3 judge present. Therefore, it's a non-judicial legislative act targeted at landowners, which means they are insurrectionists. The Attorney General of Texas is required to protect the defendant and his right to own land. It is true that in common law, the duty of the Attorney General is to represent the king, him being the embodiment of the state. But under the democratic form of government now prevailing, the people are king. So the Attorney General's duties are to that sovereign rather than to the machinery of government. I think that just nails it there. But instead, Paxton is busy misappropriating public funds to defend those responsible for the theft. Because they are 14th Amendment citizens practicing law only in federal areas of Texas as required by Texas codes as described herein, and because the defendant is posterity as found in the preamble as evidenced by the affidavit of citizenship, a true copy of which is attached hereto in the appendix at pages 1 through 24, all of which is incorporated herein by reference in its entirety. Therefore, they have engaged in insurrection and rebellion against the United States, giving aid and comfort to the enemy in a time of war, and they have disqualified themselves from holding any office under the United States or any state as found in Section 3 of the 14th Amendment. No person shall be a senator or representative in Congress or elector or president, vice president, or hold any office, civil or military, under the United States or under any state who shall have previously taken an oath as a member of Congress, as an officer of the United States, or member of any state legislature, and the executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or giving aid or comfort to the enemies thereof. Common law requirement. The Constitution of the United States, dated September 17, 1787, has never been declared void, is the oldest written constitution, still in effect today, wherein Article 1, Section 1 states all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Article 1, Section 8, Clause 9, it states that Congress shall have power to constitute tribunals inferior to the Supreme Court. The Constitution could only be referring to our one Supreme Court in and of the common law, which was already established and active in America and the United States of America It is clear that the Constitution is now setting up another set of courts called legislative courts, and they refer to them as inferior courts, meaning inferior to the already existing common law courts. Our one Supreme Court, and is verified by Article 7 an amendment to the Constitution, where it guarantees in suits of common law, no fact tried by a jury shall otherwise be examined in any court of the United States than according to the rules of the common law. The Supreme Court, talked about in Article 3, establishes a legislative inferior Supreme Court of the United States for the District of Columbia for fictitious entities under the Commerce Clause. Article 1, Section 8, Clause 3. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. And that's Penhallow versus Doan's Administrators, 1795, which was established by an act to establish the judicial courts of the United States. That's what's established the Supreme Court of the United States. It was by an act of Congress in 1789. Therefore, by definition, it's an inferior legislative court. But the only true Article 3 court for we the people is our one Supreme Court, a common law court of the people, by the people, and for the people, and was in existence prior to the Constitution. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can be only be taken from him by law of the land, by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. This sets the courts of common law separate and apart from legislative courts such as this court or the 97th District Court that the Attorney General is also misappropriating public funds to defend, otherwise being a maritime court in that any case tried can be re-examined by action of appeal. This places this court and the 97th District Court as one of the inferior courts referred to in Article 1, Section 8, Clause 9 of the Constitution of the United States. Note the difference in a trial by jury in common law as to a trial with a jury in legislative inferior courts. The judge in the inferior courts instructs the jury on what they will hear and decide upon and what they will not. There is no such provision in common law. A common law trial by jury means the jury conducts the trial. A common law trial by jury is self-executing and needs no legislative implementation to regulating its process or confer jurisdiction. The Northwest Ordinance of 13 July 1787, less than 3 months prior to the Constitution, has never been altered by common consent in any way or manner and remains in force. The last words of the introduction or preamble of the Articles of Ordinances, Section 14, state the following articles shall be considered articles of compact between the original states and the people and the states in the said territory, and shall forever remain unalterable. Was intended to be part of the Articles of Confederation and forever unalterable, and all previous engagements entered into under Article 6, Clause 1, includes the Northwest Ordinance, which is in full force effect today in Texas. The Compact Agreement is a federal injunction, defines the nature of federal jurisdiction and federal territory, and is forever unalterable either by legislative Congress or its legislative Supreme Court or its other inferior courts or the administration. It is protected by Article 4, Section 2, Clause 1 of this Constitution for the United States of America, which guarantees the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Article 2 of the Compact Agreement states the inhabitants of said territory shall always be entitled to the writ of habeas corpus and of trial by jury and of judicial proceedings according to the course of the common law. Legislative statutory law is in fact an extension of maritime law. The 1946 Administrative Procedures Act, Title 5, United States Code, Section 559 at Sentence 2 requires the administrative law to be compliance with and in conformity to this Constitution for the United States of America and the common law with all its prohibitions, restrictions, restraints, and limitations imposed by the enumerated bounds and boundaries as described in the first 10 amendments. History is clear that the first 10 amendments of the Constitution were adopted to secure certain common law rights of the people against invasion by the federal government. The Maritime Code, otherwise known as statutory law, being administered in legislative inferior courts. This court in the 97th District Court, as evidenced by the maritime gold fringe flag or the corporate seal in the courtroom, also acknowledges that when brought inland beyond the high water mark and the first bridge of any navigable river, they must be brought into compliance with and in conformity to this Constitution for the United States of America and subject to the common law. And this is 1 Stat 77. It says, saving to sailors, to suitors in all cases, the right to a common law jury, common law remedy where the common law is competent to give it, shall also have exclusive original jurisdiction, cognizance of all seizures on land and other waters that is aforesaid made, and all suits for penalties and forfeitures incurred under the laws of the United States. And then at 36 Stat 1611, it says, third of all causes of admiralty and maritime jurisdiction, saving to suitors in all cases the right of a common law remedy where the common law is competent to give it. And so that's in 36 Stat. That's the judicial code that was passed in the early 1900s. That became ultimately 28 USC, which is actually passed as positive law. But anyways, thus meaning competent, common law is not extending in reverse of the high water mark or extending to steer or the jurisdiction of maritime law or to exercise jurisdiction as stated in the Constitution under Article 1, Section 8, Clause 17, and minor estate where it declares that the inferior tribunals will exercise exclusive legislation as prescribed by Congress over the district not exceeding 10 miles square, as made by session of particular states, and the acceptance of Congress become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state, in which the state shall be for the erection of forts, magazines, arsenals, and dockyards, and other needful buildings, to make all laws which shall be necessary and proper for carrying into execution of foregoing powers. So that's Article 1, Section 8, Clause 17, and then the second part is Clause 18. Well, let's see what's happening on the chat. Well, if they we'll see about the appeal. I mean, it depends on the real judge is going to show up, and he's going to make a decision. And if he dismisses it, he follows the recommendation of the magistrate judge. Then he'll dismiss it, and I'll do a notice of appeal. He might change. I mean, the stuff I brought up here, I brought up some stuff that we're going to talk about here today. But so they might change it too. We'll see. So you can't see it. It looks like it's pretty legible in the window. I can upload the Word file or put a Word file available in Google Docs and have a link to it in the chat. I can do that if that's what people want. See, we're going to go into some stuff here about that minor estate. I haven't gotten, this is only page, let's see, what page is that? We're on page 18. And so it's a 29 page, so there's another 9 pages. And we're going to go through some stuff about the minor estate that I think that would help you with your, yes, I'm live streaming in real time. I think it will help you with your probation. You got to go to the probate court and declare that you're alive. Right? Yeah, that seems to work. But anyway, so I'm bringing that up in this case because it's clearly they're attacking that minor estate. So anyways, so let's keep going here. So therefore, all legislative courts, federal and state, have jurisdiction in the District of Columbia only under the Commerce Clause, which is why they use zip codes, which are only in the District of Columbia, and commercial paper / Federal Reserve notes / forced loans, which are only for use in the District of Columbia, 12 USC 411, and the Gold Reserve Act of 1934 at 48 Stat 344. See, all these references are up in that list of authorities up in the front. Legislative statutory inferior courts themselves admitted the validity of the common law court in Strauss versus Strauss, 1941, which states every system of law known to civilized society generated from or had as its component one of three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws its subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. Whereas we learned that the law of the land means the common law, State versus Simmons, Justice O'Neill speaking for the court in Taylor versus Porter, Webster's definition of the law of the land at Dartmouth 4, Wheaton 518 at 581 and 582, which is affirmed by Article 6, Clause 2, which declares that this Constitution shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. And Wiley versus Commons, 1851, acknowledges the common law and the Holy Bible from which it came, which is the foundation of the common law and our God-given constitutionally secured right. The 97th Congress declared the Holy Bible to be the Word of God by joint resolution 96 Stat 1211. This legislative inferior court fails to be an Article 3 court, and this is Balzac versus Puerto Rico. There's no Article 3 courts out there except the common law courts. The United States District Court is not a true United States court established under the Constitution, Article 3, to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3, of making all needful rules and regulations respecting the territory belonging to the United States. And that's Balzac versus Puerto Rico, U.S. Supreme Court. This court is required to provide to the demanded a Republican form of government, Article 4, Section 4 of this Constitution for the United States of America, and as one of we the people, the demanded is a state in this union because we the people are the state and have immunity against the county of Montague under Article 11 and Amendment. The government's but an agency of the state being the sovereign people. No state legislature or executive or judicial officer can war against the Constitution without violating his undertaking to support it. The constitutional theory is that we the people are the sovereigns, the state and federal officials only are agents. The state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. And a Republican form of government fails to include the District of Columbia Commerce Clause under Article 1, Section 8, Clause 3 because of Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square. And an act of Congress precipitated all of this. Federal question. Your Code of Law for the District of Columbia, Title 28, USC 1331, federal question applies because the taxation of land originated with an act of Congress under 12 Stat 292, provided for a corporate tax on the state of Texas, in this case, by apportionment, okay? And apportionment is you have to understand, it's a tax that's applied to the state, but it's based on population. So each state has a tax they have to pay based on population. But it sets up the whole mechanism that you see, that tax assessors and collectors at Section 9 at 12 Stat 296, they're required to execute a bond at Section 10 and at 12 Stat 296. They have an oath of office at Section 11 and 12 Stat 297. Secretary of the Treasurer to provide regulations at Section 12 at 12 Stat 297. A direct tax on lands and lots of ground at Section 13 at 12 Stat 297. A Board of Assessors at Section 25 at 12 Stat 300. Tax liens at Section 33 at 12 Stat 303. And every collector shall exercise or be guilty of any extortion or oppression under color of this act shall be liable. Section 43 at 12 Stat 307. And a penalty for taking false oath, perjury of oath at Section 47 at 12 Stat 308. And there shall be allowed in full compensation for their services a commission. They get paid a commission at Section 48 at 12 Stat 308. And all regulations are for other property of the United States under Article 4, Section 3, Clause 2. And if anyone thinks that the defendant is subject to any regulations, a slave, all they need to do is name a date, time, and location, and the defendant will come armed, and we can settle it for once and for all. Texas codes are Commerce Clause only. The Texas Tax Code only applies in federal areas of Texas under the Commerce Clause, Article 1, Section 8, Clause 3. In this state, this is Texas Tax Code 151.004, in this state. In this state means within the exterior limits of Texas and includes all territory within the limits ceded to or owned by the United States. Because the word includes is limiting, and that's Montello Salt versus Utah. Include, or the participial form thereof, is defined to comprise within, to hold, to contain, enclose, comprise, comprehend, embrace, involve. Include is Latin for includere, to shut in, keep within, to confine within, hold as an enclosure, take in, attain, shut up, contain, enclose, comprise, comprehend, embrace, involve. That's Premier Products. That's also Black's Law Dictionary, 6th edition, which means that when they use the phrase in this state in any of their codes, it is only talking about territory ceded to or owned by the United States. And all legislative inferior municipal fake court judges are 14th Amendment U.S. citizens and practice law only in the federal areas of Texas because it is in the state. And this is Texas Government Code, Section 330.006, Judge. It says, have 2 or more years of experience practicing law in this state. An assistant prosecuting attorney is licensed to practice law only in federal areas of Texas because it is in this state. And so an assistant prosecuting attorney must be licensed to practice law in this state. Texas Government Code 41.103. All judges practice law only in federal areas of Texas because it is in this state. To qualify for appointment as an associate judge under this chapter, a person must have been licensed to practice law in this state for at least 4 years. Texas Government Code, Section 54A.003. All bar members are allowed to practice law only in federal areas of Texas because it is in this state. And this is the Government Code 82.004. The Board of Law Examiners, acting under instructions of the Supreme Court as provided in this chapter, shall determine the eligibility of candidates for examination for a license to practice law in this state. And all juries are only for federal areas of Texas because it is in this state. And this is Texas Government Code 62.0131, form of written jury summons. The Office of Court Administration of the Texas Judicial System shall develop and maintain a model for the uniform written jury summons in this state. You know, the first thing, if you want to get off of some jury, all you got to do is tell them you're not a U.S. citizen, and they'll have you out of there so fast your head will spin. All law enforcement agencies are only in federal areas of Texas because it is in this state. Texas Code of Criminal Procedure. In this article, law enforcement agency means an agency of the state. Each law enforcement agency in this state shall adopt a detailed written policy on racial profiling. All arrest warrants are effective only in federal areas of Texas because it is in this state. Texas Code of Criminal Procedure, Article 15.06. A warrant of arrest issued by any county district judge or by a magistrate, except mayors of an unincorporated city or town, of an incorporated city or town, shall extend to any part of the state, and any peace officer to whom said warrant is directed, or to whose hands the same has been transferred, shall be authorized to execute the same in any county in this state. All search warrants are issued only in federal areas of Texas because it is in this state. A search warrant is a written order issued by a magistrate directed to a peace officer commanding him to search to whatever. And then it goes paragraph B, no search warrant shall issue for any purpose in this state unless sufficient facts. The Texas codes are effective only in federal areas of Texas because it is in this state. And this is repealing clause, Texas Code of Criminal Procedure, repealing clause. Except as otherwise provided in this article 54.02, all laws related to criminal procedure in this state. All government agencies and political subdivisions are only in federal areas of Texas because it is in this state. This is Texas Human Resources Code, Interagency and Intergovernmental Cooperation, Section 201.004, Part 2, Government Agencies in this state. Texas Civil and Practice Code is only for federal areas of Texas because it is in this state. The rule of decision in this state consists of those portions, and that's Texas Civil and Practice Code, Section 5.001, Rule of Decision. The demandant heard that there are no federal enclaves in Texas, and that's U.S. versus Bevins. The exclusive jurisdiction that the United States have important dockyards ceded to them is derived from the express assent of the states by whom the cessions are made, but that in this state includes also property that's owned by the U.S. government. So but there's no enclaves. The state of Texas has authority over anything that exists by its own authority or is introduced by its permission, and the demandant was not created by Paxton's bar members, nor Paxton, nor the state of Texas, nor the United States. And in fact, the opposite is true. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. A corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. And it's interesting to note that the Texas legislature right now, at this minute, has a bill before it to make property taxes, to get rid of property taxes. Did you know that? Yeah, that's true. Yeah, they've introduced it like within the last week, eh? They see the shit coming downhill. Anyways. After Congress passed the act that precipitated all of this, August 5th, 1861, at 12 Stat 292, and the Texas legislature passed an act defining what money and property is subject to taxation or exemption and a mode of listing the same. August 21st, 1876, Section 1, be it enacted, the Texas legislature of the state of Texas, that all real and personal property in this state, the property of corporations now existing or may hereafter be created, and the property of all banks or banking companies now existing or may have to be created, and of all bankers. That's it. There's nothing else that's included. And for corporate-owned property, in Section 4, the term person, whenever used in this or any other act regulating the assessment or collection of taxes, shall be construed to include firm, company, or corporation, which means it's only firm, company, or corporation, which means further evidencing their intent to assault with the demandant with their minor estate at 31 CFR 363.6, when Heger authorized the chief appraiser may require rendition that's not mandated by the tax code, as found in the instructions for Form 50-141 near the top of the first page, a true copy of which is attached hereto in the appendix at page 46 to 47, all of which is incorporated herein by reference in its entirety, which means Heger authorized the theft of the demandant's land and evidencing Paxton's and Heger's intent to be principals under 18 U.S.C. Section 2 and accessory under 18 U.S.C. Section 3 to the theft of the demandant's land, which also evidences the involvement of the executive branch in this matter, and the perjury of oath by the bought and paid for fake Judge Patricia Coleman Byers, when she's working for the executive branch in violation of the Texas Constitution, Article 2, Section 1. The powers of government in the state of Texas shall be divided into 3 distinct departments, each of which shall be confided into a separate body of magistracy, to wit, those which are legislative to one, those which are executive to another, and those which are judicial to another. And no person or collection of persons being of one department shall exercise any power properly attached to either of the others, except in the instances herein expressly permitted. And that's Texas Constitution, Article 2, Section 1. And with Byers' Star Chamber and further evidencing of the Bill of Pains and Penalties status of Byers' fake judgment that is a legislative act against a landowner. Demandant has lots of first-hand knowledge of how much Paxton and his bar member attorney buddies love to perjure their oaths to support the supreme law of the land, all of which is evidenced by the fact that they're assaulting the demandant with their minor estate because it is an entity, as described in 31 CFR 363.6, because an entity includes the estate of a living person, such as an incompetent or a minor. And so it says right here, includes the estate of a living person, such as an incompetent or a minor. And a minor can anyone who has attained the age of 18 years, but has not yet taken control of the securities in the Treasury Direct account. A minor means an individual under the age of 18 years. The term minor is also referred to an individual who's attained the age of 18 years, but has not yet taken control of the securities contained in his or her minor account. To use the Commerce Clause, Article 1, Section 8, Clause 3, to bring the District of Columbia plenary dictatorship. Plenary is a court's full and absolute power of the subject matter and the parties in a case. Plenary is full, complete, entire. It's a dictatorship. Plenary power, complete power over a particular area with no limitations. The term is often used to describe the commerce power of commerce. Under the Commerce Clause, Article 1, Section 8, Clause 3, commerce is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. And that's the Legal Information Institute. That's Cornell Law School, which means no common law rights outside a maximum of 10 miles square. And this is National Mutual Insurance Company versus Tidewater Transfer Company, USC Supreme Court, 1948. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington, District of Columbia, and through their plenary power, see, that's dictatorship nationally, covers those citizens even in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union, in violation of Article 1, Section 8, Clause 17, and use it as justification for the theft of the demandant's land because any administration of a living person is void. And this is Bank of Jonesboro versus Wilson, 1931, and this is taken from Corpus Juris Secundum, Executors and Administrators, Section 16, Jurisdictional Requisites, page 713. It is absolutely essential to jurisdiction that the administration of an estate, that the person on whose estate such administration is granted is dead. A living person has no estate subject to probate, and there is no vested right of inheritance in the estate of a living person. Any administration on the estate of a living person is void, and it is deliberate, calculated, and malicious by these County of Montague corporate thieves and their bar member handlers. And it goes on as executors, page 714, the next page. On the other hand, it has been considered that the invalidity of the estate does not relate back, but it is invalid only from the time when the presumption of death is rebutted.
You said estate. It said administration. You said estate. Read that over again. On the other hand,
it has been considered that the invalidity of the administration does not relate back, but it is invalid only from the time when the presumption of death is rebutted. Because the invalidity of the administration does not, and I'm saying it right here, but it is invalid only from the time the presumption of death is rebutted. And this is taken as it's Corpus Juris Secundum, but they're citing this Georgia court case, 1930. And the face of the grant deed and bill of exchange shows that it is accepted by the demandant is notarized as a living man on the soil of Texas who fails to be a U.S. citizen cestui trust a true copy of which is attached here too in the appendix at page 44 and 45, and the notice and demand that the demand is served on them on or about 13 June 2022 by registered mail to Catherine Phillips, Clay V. Riddle, Kim Jones, and Jennifer Finoglio, explaining the felonies they were engaged in and demanding to see a bona fide contract by which the men had agreed to their theft and their involuntary servitude, and they failed to produce a contract or even respond, which is signed on page 37 of the appendix by Glenn Winningham, House of Fern, a man, sovereign living soul, holder of the office of the people. Anyways, a true copy of which, together with proof of service, is attached here to it, the appendix at pages 25 through 43, all of which is incorporated herein by reference in its entirety. The minor estate was created by fraud and deception. The minor estate was created by the Vatican with the Sestake V Act of 1666, and this is the Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. Yet still it's found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holds, they devised a new method of conveyance by which lands were granted not to themselves directly, but the nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks. All of these fucking whores are just fucking Roman cult Satanists, to be bound in conscience to account to assess to use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. That's Black Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. Because a use is short for usufruct under Roman law, that the 1871 corporation operates under. The minor estate was brought into America with the Code of Law for the District of Columbia, where it says that legal estate to be in the Sestake use at Chapter 56, Section 1617 at 31 Stat 1432. No Article 3 court allowed. So let's check the chat and see what's happening there. You're right. State of Texas is the District of Columbia. So I'm setting it up to go to the Court of Appeals. So the Supreme Court has said that cases between citizens of the district, U.S. citizens, and those of the states are not included in the catalog of controversies over which Congress can give jurisdiction to the federal courts by virtue of Article 3. And that's the Tidewater Transfer Company again. It's the same case. That's the same, actually. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. And that's another reason why the court that I'm dealing with isn't an Article 3 court. It's Balzac versus People of Puerto Rico, and right there too. It's not an Article 3 court. Because all Article 3 courts may only decide cases affecting life, liberty, or property. That's Thomas. Deprivations or transfers of life, liberty, or property constitute a core of cases that must be resolved by Article 3 courts. There's no Article 3 courts, which has been previously affirmed in numerous cases that the legislative inferior courts. Where controversies of such a character as to require the exercise of judicial power defined by Article 3 jurisdiction thereof can be referred only on courts established in virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal, or, of course, in an executive officer or administrator or executive board, since they are incapable of receiving it. And this is Williams versus United States, 1933. This is nothing new. Each of these wrongdoers in this case are required to know they're operating under color of law. Color means a semblance, the appearance or simulacrum as distinguished from that which is real. a prima facie or apparent right, hence a deceptive appearance, a plausible assumed exterior, concealing a lack of reality, a disguise, or a pretext. Colorable, that which is in appearance only and not in reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. Color of law means the appearance or semblance without the substance of legal right, misuse of power possessed by virtue of state law, made possible only because wrongdoer is clothed with authority of state as action taken under color of law. They were given an opportunity to provide a bona fide contract in the Catherine Phillips Notice and Demand, a true copy of which, together with proof of service, is attached hereto at the appendix at pages 25 through 43, all of which is incorporated herein by reference in its entirety, and they failed to do so. And when they acted outside the law in support of their targeted justice.com agenda, in support of the Joint Terrorism Task Force, because the demandant is a targeted individual and sovereign citizen, they surrendered any immunity they may have had. Ignorance of the law does not excuse misconduct in anyone, least of all in a sworn officer of the law. Therefore, they are acting in their private capacity and the principals and accomplices to the theft of the demandant's land, and are personally liable in their private capacity, are nothing less than government gangsters, as described in Kash Patel's very informative hour-long movie entitled Government Gangsters, found on BitChute.com. Constitutional and natural law premises. This is actually something that somebody sent me, and I thought it would be interesting to throw it in just in case. We'll see. It might give them an out. Natural right to property. Under natural law, property is an unalienable right to the people. Inherent in that right is the understanding that property ownership should not automatically carry burdens such as taxation unless an explicit governmental authority granted by the sovereign people, which is the demandant, imposes such on an obligation to which they presumptively consent. Articles 9 and 10, an amendment, are reserved powers. Article 9 and 10, an amendment to the United States Constitution, reserves to the states or the people all powers not expressly delegated to the federal government. Since no federal statute imposes ad valorem tax on private property, well, they don't. They impose what they do is it's an ad valorem tax, but it's by apportionment, so they impose it on the state. They tell the state that you have to pass acts. You see what I'm saying? Anyways, the federal government has not asserted a direct tax burden on property. This federal silence implies that in accordance with the natural order, property is not inherently taxed by the federal government. The tax statutory framework default rule in Texas property tax law is codified by the Texas Tax Maritime Code, is built on the principle that all real and tangible personal property is presumed taxable unless an express exemption applies. Texas Tax Code 11.01a states all real and tangible personal property the state has jurisdiction to tax is taxable unless exempt by law. The statutory language establishes that property is presumed taxable unless a specific exemption is provided. Section 11.12, federal exemption. Critically, Texas Tax Code Section 11.12 provides property exempt from ad valorem taxation by federal law is exempt from taxation. Although this language does not say all property is exempt, it establishes that as federal law exempts a property from ad valorem taxation. That's why if that tax law, that act of Congress is they tax corporate property, and it's not all property. Anyways, then that exemption must also be recognized at the state level, since there's no federal imposition of ad valorem taxes on private property, and by natural law, the inherent right of property ownership is not to be burdened. The statutory framework supports the notion that unless the state positively defines a class of taxable property, the default reserved status of the people's property is one of exemption from federal ad valorem taxes. Interpretation of exempt in this context, taken together, Sections 11.1, 11.12 of the Texas Tax Code construct a system in which universal property, every parcel of property, is first recognized as property. Positive classification as taxable. The state then, through explicit statutory criteria, identifies which property is taxable. Commentary exemption. Consequently, property that does not meet the positive criteria and particularly property that by federal law is exempt or by federal government's silence on imposing such a tax retains its status as inherently exempt. In other words, Section 11.12 signals that the natural unburdened status of property as held by the people should be recognized if federal law does not legislate taxation. Saying it another way, um, since the federal government does not impose ad valorem taxes on private property and no federal statute mandates such a burden, it follows that from both natural law and Articles 5, 9, and 10, an amendment, that the inherent right to property should remain unburdened at the federal level. Texas recognizes this principle at Section 11.12. Reliance on explicit statutory language stating that property exempt from ad valorem taxation by federal law is exempt from taxation provides explicit statutory support for the idea that if the federal government does not impose an ad valorem tax on private property, then that property is by construction also exempt from any and all taxation at the state level. This, by the undifferentiated language 11.12, property is exempt from taxation. The outcome, though perhaps counterintuitive in a system where a default state position is to assess and lay tax upon all property, underscores the argument that the state's imposition of an ad valorem tax on private property is a positive exercise of power. In the absence of such a positive act, and in light of the federal government's non-imposition, the natural reserved right of the people to own property free from that burden is affirmed. Logical conclusion, therefore, under natural law, Articles 5, 9, and 10, an amendment framework combining with the explicit statutory language of Texas Tax Code, Section 11.1, the default state of private property owned by the people should be construed as exempt from ad valorem taxation by federal law, unless the state expressly and positively classifies and imposes a tax upon it. In this view, the burden of taxation is not inherent in the nature of property itself, but is instead a function of a deliberate statutory choice that departs from the inherent rights reserved to the people. Universal right and reserved powers, the natural law concept in Articles 5, 9, and 10, an amendment, reserve for the people their inherent right to property, free from burdens not explicitly imposed by a constitutional or federal mandate. Texas statutory framework, Texas Tax Code establishes that property is taxable except unless exempt, and yet it specifically recognizes federal exemptions through Section 11.12. Inference for non-imposition because no federal law mandates ad valorem taxation of private property. Section 11.12 supports that the conclusion that such property by its very nature is under the reserved powers of the people should be considered exempt from federal ad valorem taxation, thereby reinforcing the idea that the default is not a burden unless positively imposed. Conclusion, under this construction, the absence of any federal imposition of an ad valorem tax on private property, when combined with the explicit language of Texas Tax Code Section 11.12, provides a strong basis for asserting that property owned by the people is, by its inherent nature, exempt from ad valorem taxation by federal law. Only when the state makes a positive statutory determination to classify property as taxable does that burden attach. This argument is rooted in natural law principles and a particular interpretation of Articles 5, 9, and 10, an amendment to the U.S. Constitution and the Texas Tax Code. In practical terms, courts have consistently held state ad valorem taxation is a valid exercise of state power. However, the reasoning outlined above presents a robust natural law inspired perspective that emphasizes the primacy of inherent property rights and the reserved powers of the people. It is bolstered by a strict and precise interpretation by both the Constitution for the United States and the state of Texas Constitution and federal and state of Texas statutes. And so you have 1101. All real and tangible property the state has jurisdiction to tax is taxable unless exempt by law. 11.12, property exempt from ad valorem taxation by federal law is exempt from taxation. and application to receive an exemption, a person claiming the exemption other than exemption authorized by section 11.1, 11.11, 11.12. Okay, the federal exemption, you don't have to apply for it. And so, which is kind of interesting. Anyway, summary. The demandant is a sovereign citizen as agreed by all the wrongdoers. That means I'm exempt under Article 9 and Amendment. Under Article 11 and Amendment, I meant. The fake Judge Byers was acting as an executive branch administrator working for the legislature in her private capacity, making it a bill of pains and penalties. It's undisputed. The demandant is posterity as found in the preamble and fails to be a corporation, minor estate, 14th Amendment citizen, and made them aware of that in the Grant Deed and Bill of Exchange, appendix page 45, and the Catherine Phillips Notice and Demand, and demanded to see a bona fide contract, appendix pages 25 through 43. It's undisputed. The wrongdoers failed to provide a bona fide contract or even respond to Catherine Phillips' notice and demand, paragraph 43, appendix pages 36 and 37, undisputed. The wrongdoers rendered the demandant's land by force, undisputed. This court is actually executive branch agency working for Congress under Article 4, Section 3, Clause 2, under the demandant's authority, and fails to have authority to make legal determinations for the demandant. Undisputed. This court is required to regulate their property, the wrongdoers named herein, under Article 4, Section 3, Clause 2. Undisputed. The demandant is entitled to a common law proceeding. Undisputed. All goes to the criminal intent of these bar members, because first they tax property they failed to be authorized to tax, and then they misappropriate the stolen money. Oh, damn, what's that? That shouldn't be there. There we go. Okay. This court is required to provide a Republican form of government under Article 4, Section 4, undisputed. The administration of any estate is void. Once they're aware that the demandant is alive and the demandant accepted the grant deed and bill of exchange as a living man, which was witnessed by an officer of the court, appendix 45. Therefore, they knew from the beginning that the demandant was alive and their administration of any estate is void from the beginning. Undisputed, because there is no federal ad valorem tax on property. There is a corporate tax only by apportionment on the state of Texas itself. It is exempt under Texas maritime codes. And so that's it. And then there's the appendix. So this is the affidavit of citizenship. I made that fairly generic because I want to use it with a passport. This is the Catherine Phillips Notice and Demand. And that's, I basically go through the law. Under the federal rules, you're supposed to, number the page in the corner, in the bottom right-hand corner. So anyways. See if anybody's got You know, I've heard all about that stuff about the sovereign citizen, and you can go ahead and believe whatever you want to believe. But we have a House Joint Resolution that says that that's because we have a Republican form of government. Now, I think it's a powerful argument. Yeah, I agree. I agree. We lost World War II. We fought the wrong enemy. Anyways, so does anybody have any questions? How long has this been going on? It should say here.
Up at the top, live, one.
Oh, there, hour and a half. Yep. Okay. So does anybody have any questions? Put them in the chat if you have any questions.
That was great work. I agree with Brian there. Great work, Brian.
Well, we'll see what happens, you know.
I'm glad I showed up tonight.
Huh?
I'm glad I showed up tonight.
Yeah.
That was powerful. I feel like I was at the opera. And I heard a symphony.
We'll go through some of my attachments. This is the Catherine Phillips notice and demand. I served in honor by registered mail. I went through the felonies, and here's this last paragraph. I think is pretty good because I kind of massaged that quite a bit about the felonies that she's going in and that they're involved in. The right here, this is the last paragraph. It says, you're hereby notice that this is a good faith attempt to get you to correct your records by taking my land off your tax rolls, and your failure to provide a bona fide contract by which I have knowingly, willingly, intentionally agreed to your taxes, and any further communication attempting to collect the taxes extortion, or because of any non-payment of your taxes extortion, shall be multiple felonies, including but not limited to all of the crimes described herein. And this notice and demand shall be evidence of your intent to engage in all of the crimes, including but not limited to those described herein. And it shall be further evidence that Clay V. Riddle, Kim Jones, and Jennifer Finoglio, and others intend to be your accomplices and co-conspirators, as well as your agreement that I file criminal complaints against all of you and your bar grievances and against all bar members in your private capacity and seek other remedies. So I kind of nailed it there, I think. Anyways, so that's the Catherine Phillips, and then I served in honor. This is the delinquent tax statement. Registered mail. Registered mail is presumed to have been delivered. Jennifer Finoglio signed for her own. K something. I wonder if that Phillips is a pseudonym that she uses because she's a coward. Kim Jones signed for her own. This is my so notice the important thing here is how I signed it. This is signed by as a living man. Right there. A living soul, sovereign living soul. And the deed. This deed is, I accepted the deed. This is important. So it's a contract. They're going to have a problem. We'll see what happens. This is going, it might go to the Court of Appeals. Here's where I accepted it. A living man on the soil of Texas. And it's verified, witnessed by a notary public. So they can't say that I'm dead. This is that Form 50-141. The chief appraiser may require rendition that's not mandated by the tax code. So that's that 50-141 for rendition. This is the fake judgment. There's no court seal on it, so it's a fake judgment. This is the challenge to jurisdiction. And that's several pages. It's 20 or 30 pages. Certificate of service. 1471 is the attorney, and 1488 is the district court. There's 1471, the liar. 1488, it's district court. I sent it to Post Office Box 167, which is the address on their website. So they just refused it, is all they did. And this is the district clerk, sent me notice of court order. It's not signed and there's no corporate seal on it. And this is where they forced me to pay the extortion, pay for the bar scum. And this is the order, I proposed order for the judge to sign. Anyways, that's about it. Does anybody have any questions? See if there's any questions. Yeah, the affidavit of citizenship is what I'm planning on attaching to a passport. Thank you. Not an affidavit of status, it's an affidavit of citizenship. Yeah, I'm thinking about getting a passport here pretty soon. I want to make sure the other one is expired by 10 years. So. Yeah, Trump has taken the gold fringe off his flags. I noticed that. He's right on the money. I think he's really doing it right. I brought forward all the rights and privileges of the original land patent, too. Okay, well, I suppose if that's all we have, that's all I got for tonight. We're going to do, this is in the evening meeting. We're going to try and do them in the evenings.
Want another tea or anything?
Sure, that'd be nice.
Any special kind?
I'll come up. I can't remember what one I got last time. Yeah. Anyways, Um, the yeah, I call it an affidavit of citizenship. Say I'm a state citizen, not a U.S. citizen. By right of blood. Will Livingston's my fourth grade uncle.
There's also a right of soil for anyone born on the state, perhaps.
So, anyways, I rail on them. They're pretty good. We'll see what happens. I had to have this thing filed by tomorrow was my deadline, and so they might get a response here pretty soon. We'll see. I'm glad that it's we'll see what happens. I'm kind of glad that it's going to appeals because I couldn't do anything. I had to stick around because I don't do the electronic filing, so I have to go down to the court all the time. So that means I have to stick around this area, and I wanted to go to Arizona for a while. So once this thing goes to the Court of Appeals, then it'll buy me a lot of time, and I'll be able to relax a little bit. Oh, I definitely filed bar grievances. I filed bar grievances against 95 lawyers. Matter of fact, that's the part I want to take to the Supreme Court about the emerging dictatorship. I want to really break it off in their ass over that shit. So we'll see. There's defects. If you want to know about land patents, a guy by the name of Ron Gibson in Oregon is the guy that's the guru on that. But I don't go to all that trouble. I know there's defects in mine. So a lot of it depends on how corrupt they are. And you just got to sue them. I've done it. Like in Arizona, it's not too bad. It just depends on how corrupt they are.
You want to talk about how you would do a bill of conveyance now as opposed to the way?
Yes, good point. Good point.
Improving your process.
First of all, there's a defect on this. There's like a couple defects. I use letter size paper, and next time I'll do it on legal size paper. And I call it a grant deed and bill of exchange, and I think that was a problem too. I should have called it a bill of conveyance. That's something I've learned from Ron Gibson, and I think that's brilliant. So there's defects. There's no doubt. Right here. This is the grant deed and bill of exchange I did. I brought forward right here, together with all the rights and privileges of the original land patent. Survey 547 granted to W. Marlette, all of which is incorporated herein by reference in its entirety. And I accepted it. The only defect there's a couple defects here. It should be called a bill of conveyance. And get rid of that grant deed and bill of exchange. It's a bill of conveyance. And I should have put it on legal size paper. That's like major problem. Well, it's a bad problem. you know. So, but there should be a meets and bounds legal description. You know what happened is I had a meets and bounds legal description, and I couldn't find it when it came time to do this thing, and so I just didn't use it. I went and got it surveyed and everything, and I got a meets and bounds. I told them I want a meets and bounds legal description, and they did it for me. And then I couldn't find it. It was like about 5 years before this happened, or more. Anyways, what happened is they were charging me $16 a year for property taxes, and that was nothing. And so I didn't. I just paid the tax. It's not worth fighting over. But then it went recently to $150 a year.
Do you think the original agreement to pay the 16 Federal Reserve notes kind of gave them some?
Well, it was titled under Texas American Holdings, and
oh, so you conveyed the title?
I transferred it.
I see. So what? So you've never paid as a man. You paid it under Texas American Holdings.
Yep. Upon receipt of 25 United States of America Silver Eagle 1 troy ounce pure silver coins, $25 in lawful money, anyways.
Question for you on that Silver Eagle 1 ounce pure silver. Is it not true that lawful money for the silver dollars were 90% silver because of that it would be, in circulation, they needed to have it harder, and therefore we should use coins that are more 1860s or something of that nature?
No. These coins are minted by the United States Mint. So I don't think it matters.
Okay, so it's silver coin.
Has a face dollar, has a face value of $1 on it.
Okay.
I can show you if you want to see it. It says right on it, $1.
So it's really the weight of the silver. It has nothing to do with how much extra.
Well,
because I know there's 2 or 3 different.
The old silver dollars weren't an ounce. The old ones, back in the 1800s and stuff like that.
I know they kept changing how many grains of silver.
Yeah, right.
Gold. So
right.
It really depends. So that's what determined it. It wasn't how much alloy.
Bonnie. One time she paid me a silver dollar, and I should have kept it. I should have said nothing, but I'm too honest, I guess. Anyways, I looked at it. It was an 1800 silver dollar. So I was sitting in the back of her car, and I said, this is an 1800 silver dollar. And I had my phone, and I went on eBay, and I
300.
This is $100,000. There was some of them for sale on eBay. I don't know if it depended on a condition and all that stuff. I don't know. But I said, there's other ones selling on eBay for $100,000. She said, give me that back. Yeah. So anyways.
So the fact that you used the words all of lots 5, 6, 8, and 9, block 14, also could have caused you a little difficulty.
Well, the Ninth Amendment's really powerful because it opens up all your common law rights. You have unlimited common law rights. So that's a really good one to use, quite frankly.
Right, and Justice Scalia often commented about one or both of Articles in Amendment 9 and 10, and he can't understand why the public's not making better use of them.
Yeah, no joke. Well, that's the lawyers, that's why. Yep. Well, there's all sorts of stuff people don't use. You know, the fact that they're assaulting you with the Commerce Clause. That's a problem for them. I guarantee you, when it gets to the Court of Appeals, that's what they're doing.
Do you think the appeal court, assuming it goes there, will address each of your claims in here?
I don't know.
I mean, are they obliged to, or they can just pick one and say this is why, and they don't bother talking about the other?
Well, you never know. They might give us something really good.
Somebody was asking who the voice is.
Who's the voice in the background? That's Nelson.
Yeah.
He's another. He's done some of my videos recently about the organic.
The original Constitution.
Yeah, the original Constitution, the organic documents that started
Yeah.
our republic.
Organic law. The organic law.
Anyways, we've been going on for close to 2 hours now, so I suppose we ought to cash it in. And thanks for watching, and I hope you get something out of it. If someone wants, I can upload a Word file or email them a Word file from this. Send me an email or ask for it to chat. There was a long time that I didn't check the chat, but I'm checking it now. So what happened in the past, somebody was wondering about censorship. In the past, what happened is all of the chat gets held. And after 90 days, YouTube deletes them. If I don't check them and approve them, then YouTube will delete them. And so I didn't check my chats for a long time because YouTube had taken my channel down, or they didn't take it down. They didn't take it down. They were blocking me from getting access to it for about 3 months. And anyways.
The one question there at 8:43 p.m. is the point I was making. Not everyone has the right of blood. It asks about after the Revolutionary War. That's where I believe the right of soil would come into play for those that don't have the right of blood equal to the right of blood. Someone asked that question.
Where's the maximum? Talks about that. Is there a maximum? Okay.
Yep.
Okay.
Right, that's where being born on the land came from.
Right.
So you're kind of, for those of us that were born on one of the states, the de jure states, that's where they don't have right of blood. It's just as good in my view.
Okay. Well,